This is case 23-1183, People versus Lott, and case 23-1185, People versus Ayers. Answers for the record, please.
Good morning, Your Honor. Elena Cisneros, on behalf of the people.
Good morning, Your Honor. Vincent, on behalf of the defendant, Tom Lott, who's seated to my right.
Your Honor, Fred Black, on behalf of Mr. Ayers, who's seated my left to counsel.
So this is the day and time scheduled for the argument on bind over. And how you guys want to approach this? I know that we had some documents that have been filed with the court in terms of what the arguments are, familiar with the arguments, and I think it's kind of like I believe that the people are arguing that the matter should be bound over based on the testimony, that the recanting witness is not credible, and the alternative that there should be a reopening of the proofs to allow for some additional information to be gathered. I don't know if we need to spend a whole lot of time talking about that part of the case, or if there's something else that I should be aware of before we kind of move to the names.
Your Honor, I would agree with the court's, summary of the people's two-part motion. Just so that the record is clear, I don't have anything new to add, but just to place it on the record, my office did receive some lab reports from the Michigan State Police by way of Detective Velocity yesterday afternoon. I did have those relayed to my office. It's my understanding those were already emailed to both defense attorneys. However, I did bring a hard copy for them today as well. There were 4 MSP reports regarding blood evidence and partial DNA evidence, and there's ongoing analysis. But I just wanted to make that a point for the record that if the court was not willing to bind over but was willing to reopen proofs, that I would motion the court to accept those as self-authenticating documents for admission.
So one of the interesting aspects of this is that there, looking at how this is sort of played out, that there is supposedly, I haven't actually seen it, but I trust Mr. Zero's representation, body cam, that indicates that there were some discussions by the alleged victim with the court, working this into the court with respect to who is the case with the said my sort of opening gambit at this point. So, off the record, okay, I'd like to go into my office and have a little discussion with you guys.
All right.
All right.
Back on the record with regard to case 23-1183, People versus Lott, and case 23-1185, People versus Mrs. Jones. Your interest really revolves in your work for the argument.
Yes, Your Honor. I would request that the court allow the people to reopen proofs either at this juncture in part with a brief continuance. I did not subpoena a whole list of witnesses today. However, I do have 2 critical witnesses that I would request the court to allow the people time to subpoena. My office can get those out as soon as 48 hours. I understand the court schedule as well as the holiday schedule. I do have Officer Ebright here, who took the initial statement from Alex at McLaren Hospital. I do have his body cam ready to be submitted to the court. However, I understand that foundational requirements would be working backwards at that point, and I would certainly be at the mercy of the court to request that. And again, I would, if the court is willing to reopen proofs, I would submit as a self-authenticating document, the certified lab reports from the Michigan State Police regarding the blood and ballistics on the firearm that was collected on the scene.
Here, I don't know what point you guys.
On behalf of my client, Your Honor, Mr. Ayers, I would indicate that we obviously object to that. We'd ask the court would not bind over and dismiss it at this particular time. If the court sees fit to reopen proofs, we would reserve our arguments pursuant to the hearsay and the foundational requirements in that area to challenge any further proofs in this particular matter. And if the court does that, there will be a new date set. I would be asking the court to consider a reduction in bond of my client. He's been sitting in jail now probably over 4 months, or closing in on 4 months at this point. Yes, thank you.
Mr. Green.
Thank you. And I would also echo the comments that Mr. Blackman just made. And on behalf of my client, I believe he's been almost 5 months. Also, if the court does second open to set a new court date, then we'd ask the court to reconsider his bond also, reduce it to personal cognizance. Thank you.
Mr. Snarls.
Thank you, Your Honor. If the court was willing to grant the people's request to reopen proofs and allow me to either do that in part on a separate day where I have.
Have they actually seen the body cam?
Yes.
They have.
Well, I'm sorry, when you say they, do you mean the defense attorneys?
The defense attorneys.
They have it. I can't speak to whether or not they've seen it. I have it up on my computer right now if they.
I don't know if I've
Probably we would not take any testimony today then, because in fairness to you guys, you need to be able to do the due diligence to review the body cam and see whether it says what, it purported to be on the body cam or to be prepared to cross-examine with regard to. I think that there is a foundational aspect of having that included on it. No, it's no secret, and I'll just say on the record, we just had a brief conversation in chambers where we talked about this issue and what my recollections are with respect to how to move forward with regard to this. I believe that under the circumstances, I'm leaning towards allowing Mrs. Snarls to reopen the proofs. I don't want you guys to be sort of ambushed by the fact that she's got a body cam that you haven't seen before. No, I think that's what her intentions were at all.
No, we understand.
I allow for her to reopen the proofs. She didn't know that. I was actually thinking that that might be something that I would do after I review the case. But that's kind of where I'm at. So, Sam, did you want to respond to anything that the gentleman said?
Yes, Your Honor, it does appear that 67 combination of video and photograph files were shared with defense attorneys back on August 19th of this year. However, I understand that that's quite a bit of time away, so I don't know that that specific body cam is fresh in their memories, but I can give them the evidence number of that body cam so they can review it. With respect to the defense attorney's request for a PR bond, should the court allow for brief adjournment to allow for the briefs to reopen, I would ask that the court, certainly I respect the court's decision given the time frame, but I would ask that the court still keep some sort of monetary bond on these defendants, as well as a GPS tether with a curfew at a specific address. Both of these individuals have a criminal history. While I understand that some of those histories are a combination of convictions and dismissed cases, I am concerned for the safety of the public if there was not some sort of additional layer, such as a tether with conditions.
So basically, what you're proposing is a house arrest situation.
Yes, Your Honor.
I think that I am probably amenable to that. I think there should also be no contact provision as well with Alexander Friedenberg. What was his sister's name? Was that Carmen Weinberger?
Yes, Your Honor, I would also ask that, that there also be no contact with any, I guess as a catch-all, no witnesses in this matter or with each other. And that is Carmen, 2 A's, and then Weinbarger.
That makes sense. So gentlemen, this is where we're sort of landing. We need to have addresses for the defendants. The defendants are going to have to be released on a GPS tethered with house arrest so that they're not out running the streets. And want to make sure that they are not in contact with either of the witnesses that I've already mentioned, Carmen or Alexander, and that actually I don't believe that they should be contacting each other either as a function of this. Will allow for it to be a PR bond, so if you're a $50,000 PR bond, so if there's a violation, a bond of $50,000 is going to kick in. Okay,
Yes, sir.
Yes, sir.
so
Apologize, Your Honor. Would the court like to state the address of my client where we had it on the record?
well, I was kind of hoping to not broadcast that to the
Oh,
world.
okay, we can submit it to the court, I guess. Yeah.
Actually, I would like to have him released to the custody of his mother.
Okay,
Ma'am, what's your name?
Carmelita Ayers.
Carmelita Ayers?
Yes, sir.
Carmelita.
M-A-L-I-T-H, sir.
Mal. So you'll be able to come to the jail a little bit later and pick them up then.
Okay,
You'll have to be released to your custody, but you'll have to be on that tablet,
that's fine.
okay?
Um,
That'll be your Christmas gift from the court. To be
Praise the Lord.
Yeah, to be
Praise
your
God.
son come with you.
Praise him.
Your Honor, concerning Mr. Lott, he would be residing with his parents, Rick Lott and Christina Lott. Chris, Christina. Code.
So we're gonna need their address as well. Actually, I'm gonna need phone numbers too. Ms. Nelson, am I forgetting anything?
Your Honor, I just wanted to specify for the record, of course, I leave it to the discretion of the court, but it's my understanding that Mr. Ayers is either in a relationship or is married to Kendra Little, who she has been in the courtroom before. I would ask that when he gets out, that all conversations be with respect to this case because she is a potential witness.
Question order basically. So one of the things that we want people to do is to have their testimony to be their own testimony. And so we have something called sequestration, that you're not supposed to talk about the case with other people that are involved in the case. So if Kendra is going to be a witness, you're saying for the people?
She's on the people's witness list, Your Honor. Whether she is
That sounds pretty tricky, but.
fruitful to our case or not is one thing.
But we can have Mrs. Lott's information.
And as I had stated to the court, I do see that Mr. Lott does have a no bond hold out of the 30th Circuit Court, Your Honor.
So then you may not get released yet. I don't know what's going on with that.
We checked on it before and it was active still, so I'm not sure, I'm not 100%
We'll
positive.
double check.
We'll double check that.
Okay.
But obviously, I would imagine that if his no bond gets changed on the Circuit Court file, that this would still be applicable and he would be able to.
I can't control another case.
Understand your.
Anything else further for the record?
Your Honor, I don't know if the parties received a date yet or if that is something that
Good catch. Let's get another day.
February 2nd.
February 2nd at what time? That's
That work for you guys? February 2nd work for you?
Sorry about
February 2nd, it's 10 o'clock.
I'm available, Judge.
Guys are contrast in technology. got pages being flipped and, yeah,
Sorry, Judge.
I'm available on Groundhog Day also.
Okay. All right. Yeah, we want to make both bonds $50,000 PR.
I'm sorry, Your Honor, I do have one more thing.
Okay.
Just so that my notes are clear as well as the tether companies, I know that the court had asked if I was essentially asking for a version of house arrest. I was not sure if the court was going to specify exactly what that meant to.
Can't leave the house.
I understand that. I just don't recall hearing that on the record.
Can't leave the house. Confined to the house. Confined to the house over on Bonnieville rather, 4085. Bonnieville.
I would imagine that would include the basic parameters such as a court appointment or if they're called in for a random drug or alcohol test.
One thing, Judge, if he's confined to the house, like, could not be released or talk to the tether company about coming to my office to talk to me, before February, or should I go to? I'll go to his house, okay.
You can even do FaceTime.
Okay, Judge, all right, I just wanted to clear that up.
That's what happens when you try to do things on the fly like this. We have to make sure we're on.
Thank you.
Mr. Green, any questions or concerns?
Nothing else, Your Honor. Thank you.
Okay, all right. Let me submit that together and, we'll see what, in terms of Mr. Lott's side of the equation.
Thank you.
So all the other bond conditions are continued that were in place before.
Oh,
Would you like to have some time to speak with him, Mr. Black?
No, I'm good. Okay. Thank you, Judge, very much. Have a good Christmas.